Bonaventure. Welcome to ATT Level 1 Commercial Class. Welcome. Today, we are going to look at the nature and purpose and classification of laws. With this classification of laws, we look at public law and private law. We will also go ahead and look at procedural law and substantive law. And we'll go ahead also and look at the remedies available to a defendant in civil actions as against the criminal actions. We are also going to touch on legal terms as used by courts of laws, and also characteristic of law. Public law and private law. Public law is the law which regulates the relationship between individuals with the state and its organs. Examples of public law: one is criminal law, immigration law, and also human rights laws and other related matters that we always see around. So public law is essentially criminal law. And when it comes to criminal law, a criminal offense is not an offense against an individual. Rather, it is an offense against the state or against all members of the society. So when it comes to criminal law, it is not like private law. Private law is a law which concerns individuals. For example, if you take a loan from a friend and you don't pay him, that friend of yours will go to court, and the court will order that you pay that fine. And after payment of the fine, the matter will have ended, and there's no much big deal when it comes to private law. But in a criminal law, the offense that you commit, for example, murder or robbery or treason or attempted robbery, that is straight away an offense against the state. And now it's the state which will take up the matter through the prosecution witnesses until you are jailed or punished accordingly. But when it comes to private law, it is you, a person called the plaintiff. If maybe you loaned somebody some money and he has not refunded you, it is you to prove that you rendered, you did lend that person your money. It is not the state. If you don't prove, then the matter ends there. But when it comes to criminal law, it is no laughing matter. It is the state which will take up the case as against the private law, where it is you to take the person to court. If you don't take him to court, the state is not concerned. So the difference between public law and private law is that when it comes to private law, it's the law of all the members, all the people of Kenya. When you break that law, you offend the people of Kenya. But when you offend a private individual by borrowing his money and you don't pay, you only offend that person because it was between the arrangement was between you and that individual. The state does not come in. It only comes in when you have taken the matter to court. Now the court will come there and solve that dispute, and maybe award you damages, or even committing to a civil jail term, as we will look at it later. So as I've just told you, we are also going to look at the remedies available to a defendant in a civil action. For example, if you borrow money from a bank or from an individual for that matter, and you don't pay, and you are taken to court, the court may commit you to jail. For a few, which is not a long period, until you pay the money. And while in that jail, it will be now again the person that loaned you money is the one who will pay your subsistence in court. It's the one who will pay for your meals in court. The state will not pay, will not incur any expenses for that person. It is you who will pay. So it becomes very expensive if you ask the court to commit a person who has borrowed you money to take him to jail, because the state will not be concerned. In fact, after it has ordered that you commit that person is going to be committed to jail, they ask you to do what? To pay the money. And if you pay the money, that man will not go to jail. Or if he goes, then the state will still ask you to pay the state the money, because the state is only allowed to use the money for criminal offenders only, but not for civil cases. So the remedy available in a civil action is that one could be committed to court until he pays at your own expense, of course, at the expense of the person that that was borrowed the money. Is the one who will have to foot the bill in prison. Two, sometimes a person might have maybe bought a car on loan and then maybe sold that car. So sometimes the company that loaned him that car may go to court and ask the court this man to bring back the car. But now the guy is not there. And because the guy is not there, what will happen is the court will ask the person that was given the car not to bring the car because it cannot be traced, but rather to pay for the car in terms of money, because the car is no longer available. Therefore, the court will ask that person to pay the car in terms of money. And that's what they call specific performance. Specifically, to not for the car to be brought because it cannot be traced. So the specific performance that the court will ask this person is to pay the owner of the car the money in terms of money, but not to bring back the car because it cannot be traced. So in civil actions, I've said two things here. One is that when you don't pay, you can be committed to a civil jail. And that civil jail, the person committing you to it is the one who will put your expenses there. Two, I've said sometimes you may have been given some property and that property cannot be traced, for example a car. Then you will be asked to pay in terms of money. Or sometimes you borrowed money and right now you have no money. What the court may do, may order that half of your land be sold to recover that money. That is all what they call specific performance. That is also called specific performance. So the specific performance can be in terms of money or in terms of property, either way. Either way. I also told you that we have public law and private law. And in public law, we refer to criminal law or immigration law or human rights law. That's what we call public law. But private law regulates the relationship between people, organizations and companies. For example, the law of contract. That's a private law. Company law is a private law. Employment law, that one is a private law. And we also have another law called procedural law and substantive law. Procedural law is how courts should conduct their affairs. For example, before you are committed to court for trial, it must be, for example, one has committed a criminal offense, and before he is committed to court for trial, the police will arrest that person first. He will write a statement in the police station, and thereafter, within 24 hours, the said person will be taken to court for plea. After pleading guilty or not guilty, a date will be set for the hearing of that case. So those procedures must be followed. And if they are not followed, then that is an abuse of court process. It has to be followed. So that's what we call procedural law. That before your case is heard, all the procedures required must have been followed. But if it was not followed, then you can contest that there was some injustice done against you. So we have procedural law, which shows the procedures to follow before one is arrested, before one is committed to jail, before one's case is heard by a court of law. There are some procedures which have to be followed. And then substantive law. Substantive law now defines what one is accused for. For example, if it is murder, it says that with murder, the punishment will be death. If it is not murder, the punishment will be a jail term of 5 years or 10 years. That's substantive law. It it now substantiates the punishment that will be given to this person who has committed maybe murder, or maybe who has committed burglary. So the substantive law states exactly the mode of punishment that will be given to such a person. I've also told you about the remedies available to a defendant in civil actions. I've mentioned committal to civil jail, also to specific performance. Also, sometimes also the remedies available to a defendant in a civil action, there is what we call injunctions. For example, you might have sold someone land, and that person has not paid you fully. He has a balance of so much that he has to pay you. So what happens if that person decides to sell the land before paying you the whole amount that he owes you? So what will happen is that you can go to court, and the court may issue an injunction restraining that person to sell that land until he pays the last cent to you. That is an injunction, you see. So that is a temporary injunction. When the man has paid the money, then he will be in a position now to sell that land. That is a temporary injunction. But there is also a permanent injunction. For example, you are married and then you divorce your wife. After divorcing your wife, when you see with another person, you feel irritated, and even you attack her, and yet you divorced in a court of law. So the court may also issue an injunction to such a husband to desist from following his wife, wherever she goes, as long as they had formally divorced under court of law directives. So that can be a permanent injunction, that if you will be seen following that wife again of yours, that ex-wife again, then legal action will be taken against you, that you are interfering with the rights of another person. So things are that way. So we have temporary injunction and also permanent injunction. Let us also look at the differences between civil law and criminal law, that is classification of law. In civil law, the civil law deals mainly with the violation of private rights belonging to an individual. For example, defamation, defaming somebody, refusing to pay a loan, or committing an offense of trespass. Now, the plaintiff, the person that you have offended, will take a case against you to a court of law. So the person to whom the case is taken against is called the defendant, and the person who takes the case is called the plaintiff. When the plaintiff has gone to court, the burden of proof lies squarely on him to prove that this man indeed refused to pay his loan, or this man indeed defamed him by insinuating that maybe this man is a thief or a robber. So it is up to the plaintiff to prove such a facts. But in a criminal law, it is the violation of public rights. And when a crime is committed, it's a crime against state, against all the members, all the people of that state. So it is the state to take up the matter, to prosecute that person. So the difference between civil law and criminal law is that when it comes to criminal law, it's an offense against state. But when it comes to civil law, it is an offense against the individual or against the company, but it's not against the state. Also, in criminal cases normally, their punishment is jail term. Whereas in the civil cases, the punishment is not necessarily jail term, because sometimes the court may just ask you to restore that money that you owed that person. You restore the money, you give back the money. You are not taken to jail, unless it was the state which you offended. If you took money of the state, then definitely the state will jail you. Like even we have seen some prominent politicians in Kenya being jailed for having swindled the government millions of money. Such a people will be jailed. But supposing the money was just from a private individual, such a person would not have ended up in prison. But so long as you swindle the government, it becomes a criminal offense. Because it is taxpayers' money that you have swindled. Therefore, you will be taken into jail. And also in criminal offenses, the standard of proof is very high. That case must be proved beyond reasonable doubt. Why is it so? It is so because, for example, if you are going to sentence somebody to death without any evidence, at all, or with very little evidence, and maybe the person never committed the offense that is being accused of, and you end up hanging that person, and later you realize that whatever was being alleged against him was just falsehood. So you would have killed the person, and that person will not come back to life. Therefore, the standard of proof in criminal cases, it must be beyond doubt, beyond reasonable doubt. But in a civil case, the standard of proof is a bit low. So long as you can allege that so and so took your money, and there was some witness, that witness will not be grilled so much as in a criminal offense. So the standard of proof in the civil cases is a bit low, but in the criminal cases it's very high. For example, in a murder case, a person must be given a lawyer to represent him, so as to show that if he will be found guilty, or if he or she will be found guilty, then he would be found guilty rightly, because the person would have had an attorney to represent him. But in civil cases, it is you to look for an advocate yourself. You can't be given an advocate at the government expense. No, it is you to look for an advocate yourself. You see? Also, in courts of law, you will see some terms used there. For example, there is this term called opita dicta. Opita dicta. Opita dicta. This is, by the way, a judgment just utter something, by the way, it doesn't mean it. And it will not, for example, if he says, hey, but you must be a very bad person, it doesn't mean that when he said so, he must convict you. No, it is just by the way. It is just a comment that he has just made. You see, that is opita dicta. Also, ratio descent. There is also another one called ratio descent. You see, ratio descent. This one is the reason for conviction, because when a judge convicts you of an offense, he must show the reason why he has convicted you. So he must really show it. That you, why did he convict you? He has to show it that he indeed convicted you, and he based his conviction on such and such a reason. You see? We also have characteristics of law. Law, it has no one definition like in other fields. Law simply prescribes and regulates general conditions of human activity in the state. So it is simply a set of rules. It regulates the human conduct. It is created and maintained by the state. It also has certain amount of stability and uniformity. It is also backed by a coercive authority of the government. Also, its violation leads to punishment. It is the expression of the will of the people of that country, and is generally written down in the form of the constitution, in the form of penal codes. It also relates to the concept of sovereignty, which is the most important element of the state. So you will see that law is a set of rules. That's what you should know. It also regulates the human conduct. It also brings a certain amount of stability and uniformity in the country. It is also backed by the government, by a coercive authority. It also expresses the will of the people, that we want capital punishment to be there, that we want people who committed treason against the government to be hanged. It simply expresses in certain ways the will of the people. The will of the people. And now, we will also look at the difference between a statute law and morality. You have heard of statute law, and law of morality. Morality. A statute law refers to written laws approved by Parliament or made by Parliament or elected leaders, while morality is simply the beliefs that if you do this and this, such will happen. But it has no basis in the laws of the country. For example, we have certain tribes in Kenya. When you give him meat and milk, you cannot take meat and milk at the same time. He will say that when you decide to take milk, because milk belongs to a cow, just drink that milk. Don't eat again, it is meat. That if you eat its meat, then you will never own cattle again. You see, those just beliefs. So they believe that way. So beliefs are just morals to guide people. Maybe that was to kind of inform people that people should not be gluttonous, that you want milk and you want the meat at the same time. Maybe that was just to control such a kind of behavior. But it has no basis in law. So you see, morality is just simply beliefs that certain behavior will be controlled this and this, but it has no basis in law. But statute law are written laws made by legislatures or MCS. And now, what is the difference between statute law and morality? Law demands an absolute subjection to its rules and commands to its rules and commands, while morality demands that men should act from a sense of ethical duty. From a sense of ethical duty. So in other words, morality are just ethical issues. Morality are just ethical issues. For example, in Kenya we have some communities, they cannot greet the mother-in-law using their hands. By their hands. They say it is wrong. But that's just a moral law. But when you go to Europe, it's different. Or when you go to some other communities, it is different. Law has an enforcing authority, a statute law. But a moral has nobody to enforce. Nobody can enforce that. Why did you greet your mother-in-law by hand that you should go to jail? Nobody. But a statute law, a law which was made by the legislative members of parliament, which was legislated in the parliament, has to be enforced by the same government, by the executive. The executive has to enforce such laws. But with moral laws, those who can just enforce moral laws would be maybe the judge, also the clan elders can enforce such. But it's up to a person to believe in them or to reject them. Nobody will force you to adhere by them. Let us also look at at forms of punishment that might be inflicted by a court. Section 24 of the Penal Code makes provision for the various types of sentences that courts may award. For example, a court may award a death penalty for the offense of murder, or treason, or robbery, violence, or attempted robbery. But in as much as it can award such a harsh sentence, but it cannot award the same sentence to a person under the age of 18 years. Those are called minors. So people under 18 years cannot be sentenced to death. Also, a pregnant woman cannot be sentenced to death, because when you kill a pregnant woman, it means you are going to kill the woman plus the baby inside her womb. And that baby has done no offense. So they will wait until she gives birth is when they would kill her. And like in Kenya nowadays, they have not implemented that law for many years. The last people to be hanged were was in the year 1987. Nobody has ever been hanged again, because the government also realizes that when you kill your own people, you earn no marks. Because you are simply depopulating your country, and simply sometimes that charge is not foolproof that the person did it. So you end up just killing somebody who is innocent. So it's that way. But it is still in our statute book. If it can be carried out, it will not be illegal. It will be legal because it is still in our statute books. But recently, the Supreme Court came up with a verdict that death sentence is no longer valid, that it's illegal. And if it is legal, it means it cannot be carried out. So, in this topic, I'm talking about the forms of punishment that a court of law may inflict against a person. I've said about death sentence, treason, robbery with violence, or attempted robbery with violence. I've also said that a person under the 18 years is a minor, cannot be hanged. And also a woman who is pregnant can also not be imposed on a death penalty. But it's not the only death sentence. It's not the only form of punishment that a court may award, may inflict upon a person. We also have imprisonment. An offender may be placed under custody for many years, and the highest duration is life imprisonment. An offender may also, a fine may also imposed on an offender. Also, the court also may issue an order to take away the property of somebody who stole the money, to restore that money, to bring back the money. And if he doesn't bring, his land may even be sold to recover that money. That's also a form of punishment. The court also may order that such and such a person should compensate the other that he wronged. That's also a form of punishment. And we also also have other laws which we have adopted from other countries like in England. In England, they have common law. And common law arose from their own customs of many, many years ago. For example, in England, they don't have a constitution. They just use the common law. Courts normally just use the common law to mete out punishment to people. So common law is just a set of rules which were developed in England from their own customs. We also have equity. Equity ordinarily means fairness, equitable fairness, that a court should be fair enough to an offender. It should not, although it's going to jail him, it should not take away his rights as a human being. So also that sentence that is imposed by a court, it must be equitable. It means it must be fair. Also, there are things that you should know here. For example, in a civil case, the person accusing the other is called a plaintiff, and the person being accused is called a defendant. A defendant. But when it comes in a criminal case, the person now standing in for the state to accuse the other is called a prosecutor. And the other side is called the accused person. It's called the accused person. Here is a prosecutor, and the person being arraigned in court is called the accused person. The accused person. We could also call him the defendant. So, criminal law doesn't have much, but when it comes to civil law, we have so many laws. For example, we have law of contract, law of tort, law of property, law of succession. If you want to succeed your father's land after his death, how to go about it, law of trust, etc. But also, it must not be lost on us. We should know that law is important in society. Why? Because it protects fundamental rights and the freedom of individuals. It also provides justice to people. It also regulates human conduct. It also ensures that social and political stability prevail in the country. It also provides peace and security, because without laws, there would be a state of anarchy. People will not obey others. People will do what they want to do. So with that, my good students, we come to the end of our law class. Until next time, bye-bye.